Action's webinar, The Supreme Court Decision to Overturn Gene Patents and What It Means for You. My name is Saru Kaiser, and I'm the Education and Mobilization Coordinator here at Breast Cancer Action, and I'll be moderating our Q&A session today. On our webinar today, we have a wonderful expert panel, which includes Karuna Jagger, the Executive Director here at Breast Cancer Action, Sondra Park, one of the lead ACLU attorneys on the gene patent case, Kathleen Maxian, patient advocate,
My computer's too old that I don't.
And co-founder of the Western New York Ovarian Cancer Project, Ellen Matloff, Director of the Yale Cancer Center Genetic Counseling Program, and Roderick Cline, molecular pathologist at the Cleveland Clinic. So before we begin, I just want to remind the audience that Breast Cancer Action doesn't take money from any corporation that profits from or contributes to the breast cancer epidemic. This is an important reason why we were the only breast cancer organization that was a plaintiff on this case, and it's why we can always put patients' health before corporate profits. I wanted to let people know that for those who are active on Twitter, we will be live tweeting during the webinar, and you can follow us at BC Action. And if you want to tweet with us, we'll be using the hashtag HGPwebinar. So now, let's get started. I'd like to go through our agenda, and the format of today's webinar is a little bit different from our usual webinars. So I'll start by briefly introducing Breast Cancer Action and our panel of experts, and I'll also provide some guidelines for our Q&A portion. Then Karuna will frame the issue and give the broad patient perspective. I think I hear someone speaking on the line. I'm sorry to interrupt. I think maybe Joyce, I can hear you. Sorry to everyone. Sorry, I'm going to start over. Karuna will frame the issue and give the broad patient perspective. Then Kathleen will talk about her patient perspective. And Sondra will give a quick legal explanation of the decision. And then we'll hear from Roger and Ellen, who will frame the science of the decision. And after that background, we're going to open it up to your questions for the panel. And our question and answer session should last about 30 to 35 minutes, depending on our timing. And last, we will close with a few closing comments. So I want to give a couple of guidelines for our Q&A portion. Our discussion today will focus on the current Supreme Court's decision outlining gene patents and what it means for patients, research, and the future of gene patents. Any questions that are unrelated to this theme, I will not be proposing during the Q&A, and I'm happy to follow up with people after the webinar. When you ask a question, you can type it in at any time in the question bar on your control panel to the right of your screen. If your question is directed to a specific panel member, please be sure to preface your question with their name, and I can direct it to them. If it's a general question, you can either preface your question with all or just not put a panel member's name. Also, similar questions may be grouped together to make sure we get to as many questions as we possibly can. So Breast Cancer Action's mission is to carry the voices of people affected by breast cancer to inspire and compel the changes necessary to end the epidemic. Our advocacy is conducted through a social justice lens because the politics and policies of breast cancer disproportionately affect poor women and women of color. We have three main program priorities that include putting patients first, creating healthy environments, and eliminating social inequities related to breast cancer. And now I'd like to introduce you to our terrific panel of experts. The first is Karuna Jagger. Karuna's been Breast Cancer Action's Executive Director since 2011 and has a long-standing personal commitment to women's health, feminist policy, and health equity. Her relentless approach to addressing and ending the breast cancer epidemic have earned her recognition among social media critics as, quote, badass. Karuna holds a master's degree in economic geography from UC Berkeley with a special emphasis on women, gender, and sexuality, and received her BA from Smith College. Also on the call today is Sondra Park. Sondra is a staff attorney with the ACLU Women's Rights Project and engages in litigation, policy advocacy, and public education at the national, state, and local levels to advance the rights and civil liberties of women and girls. She is also one of the lead attorneys on the gene patent case. Also joining us is Roger Cline. Roger is the chair of the Association for Molecular Pathology's Professional Relations Committee and a practicing molecular pathologist at Cleveland Clinic, where his work focuses on the introduction, application, and use of molecular technologies for the benefit of patients. Dr. Cline completed his medical degree and internship in internal medicine at Case Western Reserve University, followed by residency and fellowship training in pathology and molecular genetics at Yale, and a fellowship in molecular genetic pathology at Mayo Clinic. Dr. Cline also has a law degree from Yale Law School. Also joining us is Kathleen Maxian. Kathleen is the president and co-founder of the Western New York Ovarian Cancer Project. She was diagnosed in August of 2009 with advanced stage ovarian cancer and then learned that the Myriad comprehensive BRCA testing given to her sister 2 years earlier did not include the complete test. Since that time, Kathleen has been a vocal advocate against gene patenting. Her story has appeared in hundreds of media publications, including a documentary short done by the ACLU. And last but not least is Ellen Matloff. Ellen is the founder and director of Cancer Genetic Counseling at Yale and one of the lead plaintiffs in the gene patent case. I'm now going to turn it over to Karuna to introduce the topic and also to frame our discussion for today.
Well, thanks, Saru. So I want to begin by saying how really wonderful it is to be here with so many of our really terrific partners as we host this panel of experts and activists. I want to note how many people it took working for so many years to achieve this victory and celebrate the people on this call and some not on this call who really made this victory happen. So my role today is to begin by providing a little bit of context and explaining why Breast Cancer Action got involved in this gene patent case in the first place. And I recognize that we have a diverse group of people on the webinar, some of whom know a lot about this case and some of whom are really hearing about it for the first time. I'm not going to go into a whole lot of background detail, but I do want to make sure that we all get on the same page so that we can have a really interesting and robust conversation shortly. So my comments, like those of all the presenters, will be very brief. I could talk for an hour myself on this webinar, but this is really about sparking a discussion and hearing from you. So let me begin by briefly explaining what the BRCA genes are. BRCA1 and 2 are two human genes found in all people. Together, these genes are known as tumor suppressor genes that are responsible for repairing damage to DNA. And for some families, mutations in these genes mean that the genes don't function as they should, and these mutations are linked to an increased risk of cancer, particularly breast, ovarian, and some other cancers. For this reason, the BRCA genes have often been referred to as the so-called breast cancer genes. Now, since the mid-1990s, late 1990s, one company has owned a patent on these two human genes. And I have to tell you, when I say this to most people, they nod along. And I sort of suspect that they think they've misheard me, or they've simply substituted in their head that one company has a patent on a gene test rather than a patent on the gene itself. And then invariably in the conversation, a couple of minutes later, the person will sort of shake their head and say, wait a minute, you're saying one company owns our genes? How can they do that? And my response is really that they're asking the wrong person, because I would say they can't. And as the watchdog of the breast cancer field, Breast Cancer Action had the foresight to get involved in this case early on. And we did this, I think a lot of people, when they think about patent cases, they're thinking about one company suing another company. And rarely do you see a grassroots organization get involved in a patent case. And so I want to talk to you about why we did this. And as an organization committed to carrying the voices of women living with and affected by breast cancer, we were seeing a number of direct harms for our members. So, again, we're moving really quickly through this material, and I'm just setting the stage and context here. The first harm is that Myriad's patent monopoly meant they offered this genetic test for the BRCA mutations at a prohibitively high cost. They are the only test on the market, and Myriad's BRCA analysis test approached $4,000. It was simply out of reach of too many women. And for these families, information about genetic risk is potentially life-saving. So we got involved in this case in order to improve access to genetic testing for women. And I'm really pleased to say we've done that. Within hours of the court's ruling, at least 5 companies came out offering lower test costs. I know one is under $1,000, and this is important. Furthermore, Myriad's test, the BRCA analysis test, was incomplete and provided inaccurate and useless results to too many women. Our next speaker, Kathleen, is going to tell her story about this, and I know Ellen also has quite a lot to say about the gaps in Myriad's BRCA analysis test. So in light of these limitations in the test that Myriad offered, another harm for women has been the inability to get a second opinion. Many of us want a second opinion for something as relatively mundane as a dental procedure. And for women considering removing healthy organs to reduce the risk of cancer, a second opinion, I think, is the least we can offer. And so now, for the first time, women who are considering their medical options have access to second opinions. I also want to say that from Breast Cancer Action's perspective, we saw these direct harms to individual women in terms of accessing meaningful results or vitally important information. But even when everything seemed to go just fine, and you know, we just saw this headline case of Angelina Jolie. So even if a woman is able to get the test, either she can pay out of pocket or she has insurance which covers the test with a minimal copay, even if she gets clear and unambiguous results, and even if she's satisfied with the results of the test and doesn't feel the need for a second opinion, even then women have been harmed by Myriad's patent because of the ways that this patent has blocked progress in breast cancer, including the development of new tests and therapies involving the BRCA genes. And you know, we will talk about this, but it's exciting to say that as a result of this ruling, all labs, clinics, researchers, doctors now have access to the human BRCA genes, and this opens the door to research and studies in new areas that may lead to clinical advances in diagnosis, risk reduction, and treatment in breast and other cancers. And this is about breast cancer, and it goes so far beyond breast cancer. We know that as a result of this ruling, research and treatment for all hereditary diseases can now advance without fear of patent infringement. So this is a sweeping ruling that ensures that the fundamental building blocks of life, our very DNA, are available for scientific and medical inquiry in advance. And I'm very much looking forward to talking about these and other issues in our discussion. And once again, I want to thank all the people who have been involved over the years in making this important victory possible.
Thank you so much, Karuna. Now I'm going to turn it over to Kathleen, and she's going to tell us a little bit about her story.
Good afternoon, everyone. In 2007, there was a lump found in my younger sister Eileen's breast by her doctor doing a routine breast exam. She had a lumpectomy and was diagnosed with stage 2B triple-negative breast cancer. Our family's reaction was shock. She was so young, only 40. And because she was so young, it was suggested that she have testing for the breast cancer gene. My parents and the rest of our family diligently researched our family histories, reaching out to cousins which we hadn't talked to in years. We gathered enough history for Eileen's insurance company to cover the test. We had heard the test was expensive, $4,000 or so, and I remember telling Eileen that if her insurance company wouldn't cover the test, I'd be happy to help pay for it as it affected our whole family. And in October of 2007, Eileen received her result, negative for the BRCA1 or 2 gene. Our family took a collective sigh of relief. We had done our due diligence. We had had the Myriad Corporation's testing. We had been told this was the only company that did the testing. We knew that they were the experts. We knew that they were the best, the most comprehensive tests available, and our family had it. We were confident with the results. Eileen began to recover from her breast cancer. Although she did struggle through chemotherapy and radiation, she was slowly beginning to gain her health and life back. I did, however, inform my gynecologist of my sister's breast cancer and her negative BRCA status, and I continued to have yearly mammograms. Fast forward to 2007. In August of, 2009. In August of 2009, at the age of 47, I was diagnosed with advanced stage ovarian cancer. Oh, so you had a hysterectomy, many people say to me. And I tell them, no, I had a debulking surgery. This is a major abdominal surgery with an incision from my groin to 2 inches above my navel. During the surgery, the ovarian tumors were removed, along with part of my abdomen called the omentum, which had tumor in it. My doctor was able to remove all the visible cancer during the surgeries. And during the surgery, she took out my bowel and ran it through her fingers to check for tumors. After the surgery, I was in the hospital for 5 days, during which time a psychologist was sent to see me, as I guess I was showing very high signs of very high anxiety. I told the psychologist I was afraid to die, and I burst into tears. I'd so been looking forward to her visit. I so hoped that she was going to say, no, that's not going to happen. We have lots of wonderful treatments, and we're going to cure you. But she just looked at me very sadly and said softly, I know. And then she nodded her head and listened to me sob. 2 weeks after my surgery, I returned to meet with my gyn-onc, Dr. DuPont, for my pathology and chemotherapy schedule. The pathology showed that I was stage 3B, which meant that the tumors were found a distance from the original site. I asked for my prognosis, and I was told that I had a 20% chance of living for 5 years. After giving me the prognosis, Dr. DuPont said to me, Kathleen, after your surgery, your mother mentioned to me that you had a sister that had breast cancer. I cut her off quickly saying, oh no, our cancer wasn't genetic. She had the test and it came back negative. Dr. DuPont had put her head down while I was speaking, and when she stopped, she raised her head and looked at me and said, we'd like to see the results. I was so confused by this. I called my father on the way home from Roswell. Dad, they want to see Eileen's test results. How could they be wrong? Remember, wasn't there only one lab in the country that did that testing? They're out in Utah, right? How could it be wrong? In early September of that year, I received a call from both my parents. Eileen had been retested. This time, the results showed that she was BRCA1. She was to have an immediate hysterectomy. To this day, I can still hear my mother crying in the background saying, it's no one's fault, it's no one's fault. And all I could think was, yes, this is someone's fault. And during the question and answer, I'd be more than happy to address whose fault I think it is and why. Since my diagnosis in 2009, I've had over 25 rounds of chemotherapy, including IP chemotherapy, intraperitoneal. This is where the chemo is delivered directly into your abdomen through a port. It's extremely toxic and painful, and only 40% of women can complete the full treatment. I've been hospitalized for a bowel obstruction. I've participated in a vaccine clinical trial. I've reoccurred twice in a periaortic lymph node. And in the summer of 2011, I was caught up in the chemotherapy shortage. I've gained and lost 50 pounds. And I've been diagnosed with PTSD. This past February, I had surgery at Memorial Sloan Kettering for a periaortic lymph node reoccurrence, and I've just finished another round of chemotherapy this past May. I am in a high-risk breast cancer program and have a suspicious something in my left breast, which is now being watched. A recent PET scan showed some suspicious FDG uptake in my stomach, although I did just have an endoscopy and it showed it was nothing. I live my life 3 months at a time between tests. In the past 30 years, there have been no new advancements in the treatment of ovarian cancer. However, there has been a new class of treatments called Parp Inhibitors that are showing some promise with BRCA1 and 2 patients. Without sharing data, as is currently happening with testing companies, we really can't, we need to be able to help these scientists do a better job at developing new treatments. And during the Q&A, I'd be happy to talk more about that. I'm going to end with telling you that the shock and angst of being diagnosed with cancer is certainly one of the worst things that has ever happened to me. But the realization that my cancer could have been prevented has been pure trauma, as well as the realization that if this happened to me, it can happen to others. That part haunts me. I'd be happy to talk later about all the women who are not given the full screening, as well as the importance of licensed genetic counselors versus corporately trained ones. We do know that genetic testing can save people's lives, but it needs to be done by professionals and it needs to be done correctly. Thank you.
Thank you so much, Kathleen, for sharing that very powerful story. I'm now going to turn it over to Sondra, who's going to tell us a little bit more about what the court actually decided.
Thank you, and thanks everyone for having me and hosting this webinar. I guess I just wanted to start off by saying it was stories like Kathleen's and many other patients, as well as professional geneticists and pathologists who wanted to be able to provide better access to testing that really drove us to bring this case. So the ACLU started looking at the issue several years ago, and while gene patents were, I think, very controversial within the scientific community, there had never been a legal challenge brought, and really several years ago the issue was not an active issue of advocacy. They were accepted. The patent office had been issuing patents on genes for over 25 years. And so at the time we brought the lawsuit, which was 4 years ago, it was certainly considered an uphill battle. And what we were challenging was the patent office's policy of granting patents on human genes once they were isolated, and that's the key word. If you want to go to the next slide. So isolated in this context, all that means is that it's removed from the human cell. And so our basic argument has been that removing a naturally occurring thing is not creating an invention. Just like if you were to remove the kidney from the body, the resulting kidney would still be a human organ. It would not be the invention of the physician who had removed it. And so the question we presented to the Supreme Court after 4 years of litigation going up and down amongst the different levels of courts was a pretty simple one, but I think also a very profound one. And the question was, are human genes patentable? And so on June 13th, we got a unanimous decision written by Justice Thomas answering that question. And so they had two parts to their ruling. One had to do with so-called isolated genes, and the court ruled that isolated genomic DNA is not patent eligible under Section 101 of the Patent Act. And what Section 101 provides is that there's a doctrine within that that says products and laws of nature, as well as abstract ideas, are not patent eligible. And so that was our basic legal argument, that isolated genes are still products of nature, and so they should fall within that exception, and they should be part of the public storehouse of knowledge that all scientists have access to. And the court agreed with us on that question. Justice Thomas wrote, Myriad did not create anything. To be sure, it found an important and useful gene, but separating that gene from its surrounding genetic material is not an active invention. And that's a really important conclusion, because for far too long, many things that were simply removed from the natural environment, like human genes, have been patent eligible. And so this was very significant from a patent law perspective in reaffirming the doctrine that products of nature are not patent eligible. The second part of the court's ruling has to do with complementary DNA. And that is DNA that is the mirror copy of naturally occurring RNA that is found in all of our bodies. we had argued that complementary DNA should also not be considered patent eligible because the scientist in creating cDNA does not actually dictate the order of the nucleotides within the cDNA. The court disagreed with us on that and found that cDNA is not a product of nature. But the court did not rule on whether other patents on cDNA might be invalid for other patent law grounds. And so, as I mentioned, the sole legal argument we made was on this product law of nature exception. But the Patent Act actually has many other criteria that govern whether a patent is valid. And so the court did not rule on that issue, and it's still an open question as to whether patents on cDNA might be held invalid on other grounds. Justice Scalia wrote a very short concurrence for anyone who's interested, and basically talking about the limitations of his knowledge on biology, but that he still agreed with the ultimate outcome. Can I do the next slide? So I just wanted to share a little bit of the early reactions to the case. There was, I think, a great response in the press and with the editorial boards of many of the major newspapers across the country. But the most immediate and important reaction from our perspective was from the Patent Office itself, which issued preliminary guidance in response to the decision in Myriad and recognized that the decision significantly changes the office's examination policy regarding nucleic acid-related technology, and that basically is referring to DNA and other nucleic acids. Examiners should not reject product claims drawn solely to naturally occurring nucleic acids or fragments thereof, whether isolated or not. And so this is really a recognition that their policy and practice for the last 25 years was reversed by the Supreme Court's decision. The NIH Director, Francis Collins, also issued a statement calling the decision a victory for all those eagerly awaiting more individualized gene-based approaches to medical care. And that was really our goal with the lawsuit. We thought that a win here would both benefit patients as well as the scientists, geneticists, physicians, and others who want to be able to work with these genes without fear of getting sued for patent infringement. I'm happy to answer further questions about the legal decision, but I'll pass it on here.
Thank you so much, Sondra. And I just want to mention, because there's a lot of really great information on this one slide, and we're going to move on, but this webinar will be recorded and archived on our website, so this information will still be accessible if you're not able to write everything down at this moment. So now, last but not least, I want to turn it over to Ellen and Roger, who will give some scientific framing of the decision, and then we're going to open it up to your questions. I'm going to first pose it to Ellen.
So good afternoon, everyone, and it's a pleasure to be here and to speak to you about the impact that these patents have had medically on our patient population. And really, this started in approximately 1998 when Myriad began rigidly enforcing their patent, and laboratories, including the laboratory at Yale, who had been performing BRCA1 and 2 testing, were shut down. And so we were all forced to send our samples to Myriad Genetics exclusively, which at first was inconvenient, but we didn't really understand the full impact of forming a monopoly. And then we saw some interesting things evolve. Although the cost of genetic technology, much like the cost of computer technology, was dropping daily as new technology was developed, the cost of BRCA testing was going up. So with our antiquated machinery at Yale, we were performing the test for $1,600 in 1998, and we watched the price of that testing rise to $3,200, and then for all the testing involved and full testing of BRCA1 and 2 to over $4,000 a patient. And we were able to see that the company was making great profits off of this testing. One of the things that I found most egregious was that the company split the testing so that patients, as Kathleen has described, who were having quote-unquote comprehensive BRCA-analysis, and the name alone seems to imply that that's comprehensive, covering all known mutations in the gene, we're actually not having testing within BRCA1 and 2 for large deletions and rearrangements. And we'd known that comprehensive BRCA analysis was missing a significant amount of mutations in patients, and we'd known this since about the year 2000, if not before. But it took Myriad Genetics until August 2006 to launch a patch test called BART analysis. And those of us who were interested in testing our patients for large rearrangements and deletions in BRCA1 and 2 in the interim were told that we could not, that it would represent a patent violation. So we had to sit and wait and wonder which of our patients carried those mutations. When BART analysis finally did launch in August 2006, we were really shocked and dismayed when Myriad, instead of blending it into their already extensive comprehensive BRCA analysis, marketed it as a completely separate test called BART testing for $650, and it's now $700. And at the time, almost no insurance companies would pay for the testing, and I do mean almost none. So until October 2012, almost no insurance companies paid for this testing, and many families, too many families like Kathleen's, who had had comprehensive BRCA analysis and been told that no mutation were found, were actually carrying a BRCA1 or 2 mutation only detected by this patch testing of BART analysis. And if they didn't have the test, and most of them didn't, their mutation was not found, often until another family member was diagnosed with breast or ovarian cancer. We also noted with horror that Myriad Genetics was not sharing their data in the public databases anymore, and that they were hoarding this data on genetic variants of uncertain significance. And so now there are some public databases being formed, including by Nussbaum's group in California, trying to share these data. And I think as time moves forward, more and more of us will share our own personal data from our centers, and hopefully that project will grow quickly. And so one of the things that we had predicted was that within 3 months of the ruling, we would have better, faster, and cheaper genetic testing for men and women with hereditary breast and ovarian cancer syndrome. What we hadn't anticipated was that within 5 hours of the ruling, at least 5 laboratories announced either current or future plans to offer that testing. So now we have competition, and now that a monopoly has fallen and the reign is over, competition is rampant, and there are now at least 8 companies offering this testing, and expect more. We also know that many of these companies are offering what we've hoped for, and that is panels of genes. So not only BRCA1 and 2, but other genes associated with either breast and or ovarian cancer and other cancer genes as well. So this is a very good thing, but what it means for our future is that we'll have better, cheaper, faster options for our patients, but we also know that the interpretation of these test results will be more complicated. And so we really are going to need very good genetic counseling before patients have testing and after they receive their test results. And this is critical. As Kathleen alluded to, this shouldn't be counseling offered by the company providing the testing. It should be independent counseling by certified genetic counselors with specialized training in this area. And so with that, I will turn it over to Roger.
Thank you very much, Ellen. I wanted to thank the Breast Cancer Action for inviting me. I very much appreciate the opportunity to participate in the webinar, and I'm truly grateful for the important role that your organization has played throughout this case, to which we owe also a great deal to the American Civil Liberties Union for taking up this cause. So I represent the Association for Molecular Pathology, which is a group of physicians, pathologists, and doctoral scientists, geneticists, professionals who actually perform and interpret the testing. And when we got involved in this case, after having been approached by ACLU, our chief concerns were three: the cost to patients, the access to patients, and the effects on innovation. And the first two have been very well covered so far on the webinar, and I'm here to talk about the third. So basically, we were very, very pleased as is everybody on this call with the decision. I think what does this mean for patients going forward from the scientific end, from the research end? I think that this decision really ensured the opportunity for scientists, for physicians all around the world to study the genome as an integrated unit. Right now, we're in the process of implementing technologies that have enormous power that allow us to sequence in a matter of hours an entire genome, to look at all of the genes for under $1,000. The potential that these technologies bring for understanding how diseases like breast cancer arise is really enormous. We have BRCA1 and BRCA2, and these are genes that have a direct and strong link to breast cancer and ovarian cancer. But there are other genes that play there are other genes that play strong roles, but there are a lot of genes that probably play minor roles. We're all a combination of lots of genes. Even patients with mutations in BRCA1 and BRCA2 have other genes that play some role in the development and progression of the disease. And what I think that this decision does is it frees us up to study these genes and really to find these important links that benefit patients. Kathleen, she mentioned Parp inhibitors, and that's one example of a class of drugs for which, because Myriad controlled the testing, it represented challenges to the development of a drug diagnostic pair, for example, that could be submitted to FDA. I think that the decision has allowed us, or will allow us going forward, to discover more drug targets. It'll allow us to select individuals for clinical trials. And we'll be able to translate the discoveries we make readily into tests for the diagnosis, for prognosis, and for prediction of responsiveness to therapies, which should be more effective and have much more limited side effects. So I think that there's a great deal of promise and hope for patients going forward, for individuals at risk of breast cancer. The other area where there will be really I think important changes was alluded. Ellen alluded to this. Myriad for several years has been keeping information that they learn when they provide testing about the significance of changes in the genes. They've been keeping that data private as a trade secret, not sharing it with the medical community. And I think that having a lot of labs coming in and testing is going to enhance the information that we learn, and it's also going to enhance the ability of people to perform studies that not only help us understand the variation and what it means. What do individual variations mean in terms of whether or not they cause disease, but also for variations, even ones that we know cause disease, how is the disease likely to manifest in patients? And so I think that the work that ACLU did and the important role of your organization is going to make a real difference in the future for the prevention and for hopefully the cure of breast cancer.
Thank you. Thank you so much to Roger and Ellen, to Kathleen, Sondra, and Karuna for really giving some background information and framing this discussion we're about to have. So I would like to open it up to your questions. And again, you can type in questions in the question bar on your control panel. And if you'd like to direct your question to a specific panel member, please make sure to put their name in the question. So Roger sort of answered this question, and I wanted to open it up and see if anyone else had anything they wanted to add. But really this question about this biodata hoarding that Myriad has accumulated, this vast database of biospecimens over the past 15 or so years, and wondering what does this biodata hoarding effect have on other companies and what other companies can offer. So I'd like to just put it out there to the whole panel.
Well, I guess I can answer. I'll answer from the provider perspective. I think what they have is they have data that is important in trying to understand the relatively small proportion of results that are for which it's unclear whether or not when you find a genetic change, whether or not it predisposes to breast and ovarian cancer. And it'll take a little while, but I think once other labs start testing and sharing data, this information is going to become widely known. There are ongoing efforts to enhance the ability to understand these types of changes, not only in breast but in other cancers, and so I expect it'll give them sort of what you might call a commercial advantage. But I think it's important to understand that most of the mutations that cause breast and ovarian cancer are of a sort that makes them that prediction relatively straightforward as compared to changes, the changes about which we're not sure. So I think I guess I say that with the idea that people shouldn't be reluctant to use other providers.
Ellen, do you want to chime in about that?
I do. From a clinical perspective, when we first started offering BRCA1 and 2, we had genetic changes that were found in genes that we couldn't determine, is this a real mutation or is this just a normal variation? And before any of us, including Myriad, had the data, we had to work it out for a few years, and we've gotten better at working it out. Even without this database, there are things that we can look for. We can look to see if these genetic changes track with cancer in the family by testing other family members. We can see if that section of the gene is important across species. So looking at human beings, looking at fruit flies, dogs, cats, we can look, believe it or not, based to see if that section of the gene is important. So do I think it will be difficult to find variants of uncertain significance? Yes, I do. My greatest concern is that we have a lot of documentation that some patients who carry variants instead of real mutations have been given the wrong information about what they should do. And believe it or not, some of those patients have actually had preventative surgeries that they later learn they don't need. So we'll get through it together, but how important for these patients to have really good genetic counseling both before and after their testing.
Thank you. There's another question, Ellen, for you. Wondering about your thoughts on people who underwent the BRCA testing before the BART test was available. If it would be useful for those people to get that test and undergo genetic counseling now.
So, and anyone who had testing and a mutation was found the first time around, and you know you're a BRCA1 or 2 carrier, you don't need BART testing. For people of Jewish ancestry who were tested for the 3 common Jewish mutations and you tested negative, that was probably pretty reassuring and still is, unless your personal and family history is so strong that it looks like we may have missed a mutation. For everyone else who had comprehensive BRCA1 and 2 testing, and especially for those people with a cancer diagnosis like Kathleen's sister who had an early onset breast cancer, your testing is not complete, unfortunately. And BART testing probably is recommended for those families and is now covered by many insurance companies. This is particularly important in families of Spanish ancestry and Middle Eastern ancestry, we've learned. But if your family history really still looks like, wow, there's something going on here, I recommend that you see a genetic counselor and see if BART testing would be recommended for you.
Thank you. There's both a comment and a question. Someone says, I'm very discouraged and amazed that only one breast cancer advocacy group stepped up. Were other groups invited to participate? And I guess I'd maybe pose that to Karuna or anyone else who might want to answer.
So I want to say that I was not, yes, Sondra I think is a good person to answer this, but I do want to say that I was not personally with Breast Cancer Action at the time that the organization joined the case, and I want to really recognize Barbara Brenner, the first executive director who led this organization for 15 years. She herself was a lawyer, and she recognized the importance of this case. She recognized that it is about breast cancer. It is also about more than breast cancer. And she was willing to do a kind of an advocacy that falls outside the scope of most breast cancer organizations. I think the other thing to say about Breast Cancer Action is that we don't take funding from entities that profit from or contribute to breast cancer, and this really frees us to be the watchdog of the breast cancer movement without conflict of interest. I know that Barbara, as well as the team at the ACLU, did reach out to other breast cancer organizations, and I think Sondra probably has more information than I have because, again, I wasn't with the organization at the time that this case was launched.
Yeah, I mean, I guess what I'll add is, you know, there were other patient advocacy groups that supported the case as friends of the court. So, you know, I think it was really wonderful that Breast Cancer Action stepped up as the only breast cancer advocacy group as a plaintiff, but I certainly want to recognize that there were many other patient advocacy groups as well as medical associations and others who supported the case in other ways. And, you know, I think the decision to be a plaintiff is a complicated one. It's one that really involves a lot of different considerations. And so I certainly don't want to, I guess, you know, question why other groups may not have done that. I think the other thing I want to highlight is we also represented 6 women, several of whom were breast cancer patients, one who is an ovarian cancer patient, and one who has a history of family history of cancer. And so, you know, we definitely wanted to represent the concerns of patients, and Breast Cancer Action as a plaintiff did a wonderful job of that, as well as the individual patients and the professionals that work with patients every day who were also plaintiffs.
Thank you, Sondra. There's a good question that asks, does a U.S. patent restrict companies elsewhere in the world, such as Europe or India? So could Myriad's patent be said to claim ownership of the BRCA genes of everyone in the world now that it doesn't relate to people in the U.S.?
So this is Sondra again. Yeah, I mean, it's interesting. Myriad actually did obtain patent rights in other parts of the world based on, the same discovery of the BRCA genes. They obtained patents in Canada, in Europe, and in Australia, New Zealand. And so, it's really interesting to look at what's happened in those other countries. They have different patent systems than what we have in the U.S. So, for example, most other countries have a greater research exception so that researchers can use patented inventions without getting sued. In the U.S., there's a very limited research exception, so that does not offer much protection for scientists who want to work with things that have been patented. So in Canada, they obtained their rights, but the Canadian government, which has a nationalized healthcare system, has largely ignored them and done testing in-house through the government system. In Europe, their patent rights were granted, but in a much more limited form. And so for that reason, there are many labs that offer BRCA genetic testing in Europe. And then in Australia, there's an interesting story there as well, where initially the company that obtained Myriad's patent rights initially were not enforcing their patents, and they said that they were going to give their patent rights as a gift to the people of Australia. They then changed their minds several years later and began enforcing their rights. And litigation has been brought there after we filed our lawsuit, and that is still winding its way through the courts right now.
Great, thank you. Another person asks, what's the relevance of the Cdna ruling, and will that end up blocking research down the road in the way a patent on DNA has done prior to this ruling?
So I guess I can answer that because I was going to talk about it and I sort of ran up to my time. So I mean I think that by and large it certainly isn't going to affect diagnostic testing, and I think that that we were all pleased about that. I think that it does this. Most of the therapeutic patents are actually Cdna. So in some senses, those entities will continue to have patent protection. I think that particularly those that were discovered earlier in time. At this point, I suspect that the Cdna patents also probably won't have a lot of relevance going forward because there are other grounds on which these patents these patents could be invalidated. As Sandra suggested, she referred to Section 101 of the Patent Act, which is actually sets an initial threshold for patent eligibility. So the initial decision is, well, it's a natural product. Is it in fact, is it eligible to be patented, or is it a natural product that can't be patented? Is there something different about it than a natural product? And the reason that the Cdna was held to be patent eligible was because it's an artificial construct. Although it contains the same information as the gene, as a chemical molecule, it does not exist in nature. But that doesn't mean that Cdnas generally are going to be patentable going forward, because I think a lot of them will be considered obvious. That being said, I mean, I think this ruling is going to overall is going to be beneficial and open the door to a lot of research that wouldn't take place. So I think it's really done a lot for everybody concerned about these diseases.
So this is Karun. I was just going to say, I know Sondra can really clarify this issue of patentability and patent eligible. But I think the shortest takeaway is, from our perspective, first of all, I think Myriad overstated the court's position on cDNA, and in fact the court, Sondra can talk about this, didn't explicitly rule that Myriad's cDNA patents themselves are valid. It simply said that they might be patentable, and then there's other provisions. But the other thing that, just to say real clearly, is that there's workarounds. And so when it comes to genetic testing, with next generation sequencing and newer technologies and methodologies, there's important workarounds for patients. So I think from our perspective, it doesn't diminish the significance of this case. I'm curious if Sondra wants to go into, or Ellen wants to go into that a little more.
I mean, from our perspective clinically, we really don't think that the cDNA is going to have a major impact on clinical research or clinical testing at this point. We're seeing this as a clear victory.
Great.
I would agree with that. From the clinical testing standpoint of view, it really it plays very little role.
So there's a question sort of related. Someone wanted to know, how does the Supreme Court decision affect gene patents held by companies besides Myriad? Are they all automatically invalid now? And what does that mean for sort of the future of gene patents going forward?
This is Sondra. So as I mentioned, the Patent Office had this policy of issuing patents on so-called isolated genes. And using that framework, they approved patents on many, many different genes. I think the court's ruling, the logic of the ruling certainly applies to any patents on isolated genes. And so that will affect many other patents, not just on the BRCA1 and 2 genes, but many other genes. The way that all works is that someone would need to try to enforce their patent rights in order for that question to be ultimately decided. What I would envision is that many laboratories and others will begin engaging in work that before this decision would be considered infringing on those gene patents, given the court's ruling invalidating those patents. And then the next thing we'll have to see is whether any patent holder actually tries to enforce their rights against laboratories that are doing that kind of work. I imagine and hope that that would not be the case given the Supreme Court's clear ruling on this issue.
Great. Thank you. We're running right up until our end time, so I'm going to take one last question and then we'll close. And I want to encourage people, if you have a burning question that wasn't answered today, to please to write to us, and we can get back to you. So the last question someone asks, specifically to Ellen, was wondering if Yale has any current plans to pursue and restart testing now after this decision.
So our laboratory director was one of the people who got the original cease and desist letter. So when we last spoke about this, he wanted to very carefully check with our internal attorneys to make sure this was legit before offering anything. So we are proceeding with caution. But in terms of our clinical service, we will certainly be taking advantage of some of the better, cheaper testing options available to us within the next few weeks or months.
Great. Well, thank you all so much for all your questions and for our expert panel and all their answers and expertise. I was going to go through sort of ways to get involved with Breast Cancer Action, and I'll send these in a follow-up email, but I want to put them up on the screen. You can sign up for our newsletter, join us on Facebook or Twitter, and you can also share this webinar with friends and family. And again, I just want to thank everyone on this call, both for our expert panel and also for all your wonderful questions and thoughtful comments today. And again, you can follow up with us at info@bcaction.org if we didn't answer your question. And please make sure to watch your email for a short survey where you can provide feedback on this webinar. So thank you all very much.
Thank you.